Good evening, everyone. Quick audio visual check. Am I audible, visible to everybody? Good evening, Sanchari, Hasika, Sindhja, और कौन है यहाँ पे? Supriya, Anushri. A very good evening to everybody. Quickly tell me I'm audible. Yes, चलो अनुश्री ने बोला भाई ऑडिबल है तो हम मान लेते हैं कि ऑडिबल है. We got a little delayed today. I'm extremely sorry, certain technical hitch, but otherwise we are on now, right? Okay. आज हमने क्या करना है? Today we are starting off with a little bit on constitution. Right now, till your last session, since we are having these Thursday to Thursday legal sessions nowadays at 7 in the evening. So on your last session with me on the last Thursday, we wound up with our sessions on miscellaneous laws, right? Ab miscellaneous laws hamara khatam ho gaya hai, so I thought why not pick up something which is interesting, something which has been appearing in your CLAT exam for the past 2 years. 2 years we have seen continuously constitution ki hamesha questions aa rahi hain exam mein, right? So it's good. It's a good idea to have your basics clear so far as constitution is concerned, right? तो ये कुछ टॉपिक्स ऐसे हैं जो कि बहुत often repeated हैं, the ones which are based on doctrines of constitutional law, right? So we are going to talk about those doctrines today. Okay, I'm getting a comment from Hasika. Hasika ma'am, एक short session रख सकते हो current legal GK का. ठीक है, okay. In fact, legal reasoning current topic की होगी. Okay, fine, that could be there. We can do that. In fact, if you are following the Clat Possible channel, you would have realized that we are having your daily GK updates, and in those daily GK updates, we are doing quite in-depth analysis of certain current topics also, right? So stay tuned on that as well. Okay, ठीक है. We can do current legal. एक काम करेंगे that after this we can maybe take up current legal as well. ठीक. अपनी sample paper to see a good score in any paper should be above 100. Above 100 तो लेके चलना है अभी, after you exclude your negative marking, right? So that is something which is very, very essential at this point in time. ठीक है, one short session. Okay, Hasika, I got it. We just do a roundup कि भाई क्या क्या important है current legal GK perspective से. We do not really go in detail, in depth about those topics, but I understand what you're looking at is sort of a list, a checklist sort of a thing कि भाई हमें at least we have a idea, right? That's what one I can gather from most of you, right? ठीक है, चलो मुस्कान भी बोल रही है यही. Okay, got it. चलो. That's something which we can always do. But today's session, like I was saying, is based on doctrines of constitutional law. In fact, initially I had the idea of doing one session on this, but when I realized the number of doctrines that are there, and not to do justice to them, I'm thinking we'll break it up into 2 sessions. That is why on your screen, what you see now is that we are actually talking about important doctrines on constitutional law. We are doing it in parts 1 and 2. ठीक है, तो आज हमारा part 1 है. Today what we will do is going to be very familiar things. Things you are very, very familiar with is what we are going to start off with today. In the next session, we'll delve into waters which are a little more unfamiliar और थोड़े different वाले हम अगली बार pick up करेंगे. तो मैंने 2 sessions में इसको divide करा है. ठीक है. Now, what I would want is, first of all, I want you guys to tell me what do you mean by the term doctrines. But doctrines बहुत ही loosely used word है हर जगह. You see a lot of this doctrine word being thrown here and there. So can you tell me what does this word doctrine mean to you? Quick in the chat box. I want all of you to answer this. Yes. क्विकली टेल मी कि भाई ये डॉक्ट्रीन्स जो हैं इसका मतलब क्या होता है? क्विक। हाँ जी, a stated principle of government policy is हसिका is saying, सिंधुजा बोल रही है principles। ठीक है, जब हम डॉक्ट्रीन्स की बात करते हैं ना, डॉक्ट्रीन्स normally it's a word which is used not only in terms of law but it is used generally also। तो generally जब हम डॉक्ट्रीन की बात करते हैं तो everywhere the word normally is used with regard to certain basic principles। कुछ चीजें जो कि बहुत बहुत important है, which are when we are talking about them, we are not saying ki they are laying down any specific law which is enforceable or something, but which are very general in nature, but which are used quite frequently. And what you would realize is this concept of doctrines is not something which is limited to our country। कुछ जो doctrines हम करेंगे, they are quite global in nature। They might be applicable in India, and they would also be applying across in other countries also, right? So generally we are talking about principles, right? So here we are talking about principles of law which have a very wide application. And generally these principles, from where do they derive their authority, is when we come to the concept of precedents, right? So through precedents they derive their authority। तो जो कोई एक principle of law होगा, वो जब एक कोई judgment उसको अथॉरिटी दे देगी, कोई जजमेंट उसको उस प्रिंसिपल को अडॉप्ट करेगी, दैट इज व्हेन दैट प्रिंसिपल becomes legally binding, or that doctrine becomes legally binding, because now it becomes a part of the concept of a precedent। precedent का दूसरा नाम क्या होता है? Can anybody tell me what is the other name for precedent? We'll just start off with what are the doctrines that we are going to do in today's class, but in the meanwhile can you quickly tell me कि भाई precedent का जो concept होता है उसको हम और क्या बोलते हैं? What is the other name for the concept of precedent? Anybody remembers the term stare decisis? That is also what is the concept of precedent known as, right? Stare decisis करके भी एक term है जो कि principle के लिए ही use होता है। तो कहीं अगर stare decisis दिया है, don't get confused, all it means is the concept of precedent कि भाई अगर कोर्ट ने कुछ बोला है then that starts acting as a binding law, right? चलो, let's start with, these are your basic doctrines, very very important doctrines of constitutional law that we are going to cover over a period of 2 sessions। there are quite a few of them, so doing them in one session is something which is just not possible, right? Okay, Tanvi is just joining in. Yes, Tanvi, we're just starting off with this session, we got a little delayed, but now we are at it, right? Okay, तो सबसे पहले हम करेंगे अपना doctrine of eclipse। Now these are doctrines, like I was saying, most of you would be familiar with, but so you have eclipse, severability, judicial review, reasonable classification, all of them things which are related to constitution, latches, due process of law। कुछ इसमें से ऐसे होंगे which are new to you, so we would be spending a good amount of time in each one of them, on each one of them। Okay, let's begin without any delay। So let's start with the doctrine of eclipse, right? Now eclipse, when you talk of doctrine of eclipse, basically is actually nothing but the concept of that solar lunar eclipse which we have witnessed in the past month also. Last month also there was a solar lunar eclipse, right? So when you are talking of the doctrine of eclipse, it derives its basis from that concept, because when you are talking about eclipse, eclipse basically refers to the concept of being overshadowed। तो overshadow वाला जो concept है, that is what doctrine of eclipse is basically about, right? So when we are talking about doctrine of eclipse, here In what context is doctrine of eclipse used is when you look at Article 13. Article 13 is where doctrine of eclipse का application आता है. Doctrine of eclipse क्या बोलता है? It is based on this particular article, which says all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall to such inconsistency be void. Meaning thereby that when we are looking at any law, जो कि this part, यहाँ हम बात कर रहे हैं part which relates to fundamental rights, right? So fundamental rights के against कुछ भी जाएगा, then that law, even if it was there before the commencement, so मतलब अगर मान लो कि 1930 का कोई act है, so in 1930 when this law came into existence, this law was very much valid. हुआ क्या उसके बाद 1950 में we have the constitution which came into being. Now when the constitution came into being in 1950, this act lost its validity. Why? Because it was against the fundamental rights. So अब ये act हमारा 1930 का हो गया invalid. So what this doctrine of eclipse basically says is that if it has become contradictory to fundamental right, does it mean that the act dies completely? No. All that is happening is it will become inactive, right? Permanently die nahi karega, but it would become inactive. And the moment the fundamental right is omitted, the law becomes active again. So jo wo inactive tha, it will become active. It will get revived immediately after this particular fundamental right is removed. So jab hum iska, if we make the sun and moon like in case of an eclipse, then what you realize is this is your act. This is the 1930 act, right? So far as till the time there was no fundamental right violation, fundamental right का chapter अभी आया ही नहीं था, constitution आया ही नहीं था, हमारा act was very much valid, right? So this act was very much valid till the time there was no fundamental right. The moment there was a fundamental right which came in the middle, this particular validity got overshadowed. अब हुआ क्या, आपका ये act हो गया inactive, which means that let's say in 1970, this particular fundamental right, which is now, let's say there was an amendment in the constitution, or ये fundamental right अब रहा ही नहीं. So if this thing is not a fundamental right anymore, what is going to be the effect on this law? Will this law automatically revive, or will this law have to be reenacted? This is where doctrine of eclipse comes into play. कि भाई यहाँ पे अभी automatically revival हो जाएगा, or will you have to reenact the law? Because 1950 में 1930 वाला act तो खत्म हो गया था, invalid हो गया था. But now since the fundamental right itself is not there, like this fundamental right is not there, so what is going to happen? Will this law gain its validity automatically, or would you have to reenact the same? Yes, can you anybody tell me what is going to happen? Reenact karoge ya auto revival ho jayega? What is going to be the result of this particular thing? Quick. Revival hoga ya reenactment hoga? What is going to be the effect in 1970 when this fundamental right is not something which is not there anymore? Right? We've amended the constitution and the fundamental right is not there anymore. So what is going to happen? Will it automatically revive, or will it have to be reenacted? Good, all of you who answered. This would lead to an automatic revival of the law. ये Tanvi, Ayush, Siddhansh, Sindhuja, very good. It's going to result in an automatic revival, right? आपको reenact नहीं करना पड़ेगा. But this is true generally in the case of pre-constitutional laws, right? Because pre-constitutional laws में क्या बोलते हैं that 1970 में 1930 से 1950 तक तो act valid था, right? Therefore, in pre-constitutional laws, it will result in a auto revival. On the other hand, similar scenario जब हम बोलते हैं कि post constitutional laws का करोगे कि भाई 1970 में कोई law बना था, it was found that it is violating fundamental right, तो उसको 71 में हमने void declare कर दिया. Thereafter 1980 में ये fundamental right ही यहाँ पे खत्म हो गया. Now what is going to happen? Will it be reenacted or will it result in an auto revival? Now this is a post-constitutional law. This is a post-constitutional law. So in this context, what will happen? Will it be reenacted or will it be automatically reviving? Revival hoga yahan pe ya yahan pe automatic revival hoga ya you will have to reenact it. If you are saying that you are reviving it, that means we are applying doctrine of eclipse in this scenario. Otherwise, agar aap bol rahe ho reenactment ho raha hai, in that case, you are not applying doctrine of eclipse in this particular scenario. So what is going to happen? Will it be a revival or a reenactment? Yes, quickly. Can I get an answer in the chat box? Now here, your answer is going to be reenactment. This is going to be reenactment. No, Ayush, it will not be automatically revived. Why? Because yahan pe kya ho raha hai that in 1970, when the act was passed, at that point in time itself, the act is not valid. Because aapka jo Article 13 clause 2 hai, what does it say? It says that the government, the state cannot make any law which is going against the constitution. So, whereas जब आप ये प्री कॉन्स्टिट्यूशनल लॉज की बात करते हो, प्री कॉन्स्टिट्यूशनल लॉज में क्या है that before the constitution came into existence, for these 10 years, let's say like from 1930 to 1950, for these 50 years, for these 20 years here, this law is going to be considered as valid. Right? Now, since this is going to be considered as valid here, the moment fundamental right is removed, the validity का जो sunshine है वो दोबारा से आ जाता है act के ऊपर. So automatically it will come into existence. On the other hand, post constitutional laws में ये चीज नहीं थी, because 1970 में when you made the act, at that point in time itself the act is invalid. Right? So if the act is invalid right from its inception, you cannot say that the doctrine of eclipse would come into play, right? So therefore, the answer will have to be here reenactment. This is regarding pre-constitutional laws. Doctrine of eclipse generally याद रखना pre-constitutional laws में ही use होता है. Post-constitutional laws में very rarely, but post-constitutional laws में doctrine of eclipse comes into play when you are talking about it being used vis-a-vis the concept of citizenship. कि भाई कुछ fundamental rights जो हैं, they are available to citizens, and there are certain fundamental rights which are available to persons, right? So if we are saying that this eclipse or this law becomes invalid, why? Because this fundamental right is available only to citizens. So far as a non-citizen is concerned, the law will still remain valid. Again, concept वही है कि यहाँ पे जो है vis-a-vis the citizen, the overshadow is happening, whereas vis-a-vis the person, the overshadowing is not happening. This is another take on the doctrine of eclipse only, right? So don't, generally one tends to think, जिन्होंने पढ़ा भी होगा eclipse के बारे में, one tends to limit doctrine of eclipse only to the concept of pre-constitutional, post-constitutional laws. No, this doctrine of eclipse can be extended to the concept of citizenship also. तो ये कौन सा फंडामेंटल राइट सिटीजन के लिए है, कौन सा फंडामेंटल राइट पर्सन के लिए, दिस ऑल्सो समटाइम्स मेक्स अ the doctrine of eclipse can come into play like this also. Take. Okay, so this is the basic understanding of doctrine of eclipse. I'm hoping this is clear. So it was a quick revision, I think, for most of you who have done doctrine of eclipse already. So let's move on to the next one. Now, next what we have is your doctrine of severability, right? Now, both these doctrines, whether you talk of doctrine of eclipse or you talk of doctrine of severability, both of them are deriving or are being applied under article 13, right? So 13 जो है वो हमारा second article है on the chapter of fundamental rights. Anybody remembers which is the first article on the chapter of fundamental rights? अब constitution के doctrines कर रहे हैं तो थोड़ा थोड़ा revision हम साथ साथ कर सकते हैं. I think it will come in handy for everybody. So can anybody tell me part 3 जो कि chapter of fundamental rights है वो कौन से article से शुरू होता है और पहला article कौन सा है? Quick quiz time. So which is the article from where part 3 begins, and what is that article contain? Can anybody quickly tell me? What important article hai? A quick revision on your chapter of Constitution. No, Ayush, article 14 तो इसके बाद आएगा ना. हम बोल रहे हैं पार्ट 3 का स्टार्टिंग कहां से होता है? पार्ट 3 का स्टार्टिंग होता है आर्टिकल 12 से, राइट, विद द डेफिनेशन ऑफ स्टेट, राइट? सो आर्टिकल 12 विद द डेफिनेशन ऑफ स्टेट इज द चैप्टर ऑन फंडामेंटल राइट व्हिच बिगिंस. ओके, सो दैट्स योर स्टेट. ठीक है. ओके, ओके, सिंधुजा इज सेइंग 19 to 21. बच्चा 19 में आपकी लिबर्टीज शुरू होती हैं, बट आपका जो part 3 है, which the chapter on fundamental rights starts from article 12, which gives you the definition of state. ठीक है, तो definition of state से start होता है आपका article 12. ठीक. Now let's begin. Now when you look at the doctrine of severability, अब severability क्या है? पहले आपने state define कर दिया. And why do we define state? Because most of the fundamental rights are enforceable against the state, right? That is why there is this definition of state which is given in article 12 itself, right? So we are not going in for that right now. We are moving on to article 13. Now article 13 again talks about laws which are going against fundamental rights. So if there is any law which is inconsistent with fundamental rights, in that case, such a law is going to be declared as void. Now, the question arises that would this mean that the entire law would be declared void, or would only a certain specific part of the law should be declared void, जो कि offending part है? Offending part मतलब जो कि actually violate कर रहा है आपके fundamental right को, right? So let's say this is the whole act. अब इस पूरे एक्ट में से should the offending part be declared as void? This is the part of the act which is offending, जो कि fundamental right को offend कर रहा है. Or should this entire act, in its full, should this entire act be declared as void? Now, if you look at the doctrine of severability, or if you look at article 13, it says, in so far as they are inconsistent with the provisions of the part, they shall be declared void. That means कि जितना inconsistency है आपका, तो as per this principle, it seems as though only this part, the part which is inconsistent, is going to be declared void, and rest of the act that will remain valid. जो बाकी का बचा हुआ act है वो आपका valid होगा, right? Now here is where the doctrine of severability comes into picture. Because what does severability say? Severability बोल रहा है अगर आप उसको sever कर सकते हो. If you can sever the offending part and you realize that the rest of the act still makes sense. Rest of the act is not something that is becoming completely illogical, or जो भी आपको objective था, जो आप achieve करना चाहते थे act के अंदर, it cannot be achieved. Then you are going to declare only you are going to declare only the severed or the cut off wala jo part hai, that is going to be declared as void. Rest of the act will remain as valid, right? So, but can anybody give me an example of this? कि जहां पे आपने देखा होगा कि भाई ये offending part ही cut off करा है and rest of the act remains. Generally, this is what happens. All the times when all these very, 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 very popular cases on, you must have heard of adultery, जोसेफ शाइन का जजमेंट आया, द नाज फाउंडेशन जजमेंट ऑन होमोसेक्सुअलिटी, एंड ऑल दोस नवतेज सिंह, ये सारे जो जजमेंट्स आए थे जहाँ होमोसेक्सुअलिटी, अडल्ट्री, ये सब जब कोर्ट ने बोला कि ये ऑल दीज आर वॉइड, सो ये किसके सेक्शंस थे, कौन सी लॉ के सेक्शंस थे? क्विकली टेल मी, अडल्ट्री, होमोसेक्सुअलिटी, which act were they a part of? Which act were they a part of? They were a part of the Indian Penal Code, right? तो अब ये जो सेक्शन था अडल्ट्री का, ये जो सेक्शन था होमोसेक्सुअलिटी का, ये जब हमने बोला कि ये void है, did it mean that the entire IPC was declared void? But only the offending part, good Akshat, good Tanvi, only the offending part was declared void, right? So since only the offending part was declared void, what are we doing? We are cutting off, we are severing, because जब हमने adultery हटा भी दिया IPC से, it does not mean that IPC lost its significance. On the other hand, there could be a case wherein the moment you cut off the offending part, the entire law stops making sense. Right? If that is the scenario, the entire act will stop making sense, then the entire act is going to go away. So if you cannot meet the objective of the act, or if the act becomes does not make any sense, then in those scenarios the entire act would be declared void. Otherwise, usually it is going to be the severed part which is going to be declared as void. So that's your doctrine of severability. Very often tested area. Doctrine of eclipse and doctrine of severability are very, very often tested areas. I hope this concept is clear to you. ठीक है, तो अगर ये पूरा का पूरा सेंस नहीं बनाता तो फिर पूरा का पूरा चला जाएगा, otherwise only the offending part is going to go. Okay, now let's move on. Next is your doctrine of, if any, okay, next is your doctrine of judicial review. Now, when you are looking at the doctrine of judicial review, I think is something which everybody is familiar with. Judicial review is when you're talking about the power of the judiciary to interpret the law. In the sense, cannot just interpret, but they have the right to declare something which is inconsistent with the constitution as void, right? So here is where the term ultra vires comes in. Right? Something which is ultra vires the constitution is something which is going against the constitution. Now, somebody had posted a question on this. Let me just check. Okay, it's gone, can't find it. Somebody posted a question regarding ultra vires and intra vires. Okay, so ultra vires is when you're saying you are going against the constitution. So constitution ke against agar koi bhi provision ja raha hai, then who has the right to do it? It is either the Supreme Court or the High Court which have the power to declare it void, right? That's pretty simple. Ultra vires ka opposite hota hai intra vires. Intra vires is going to be something which is within the constitutional within the constitution, right? So if something is within the constitution, it will be valid. Something goes out of the constitution against what is given in the constitution is going to be declared as void. This is fairly simple, nothing much there, but something which you should be generally aware of. So I mentioned it here. Application kahan hota hai? Iska article 13. Again, laws inconsistent वाली जगह वहां पे judicial review का power देते हैं. 32 and 226. This is generally where how your doctrine of judicial review is being utilized, right? So 32 is the writ jurisdiction of the Supreme Court. 226 is the writ jurisdiction of the High Court. Which is wider? Can anybody tell me? Between the two, between 32 and 226, which is wider? इन दोनों में से वाइडर कौन सा है? 32 is wider or 226 is wider? Good. Wider is going to be good. Tanvi, Akshat, the wider of the two is 226. Good, Ayush. Now here, the only reason why it is wider is 32 में सिर्फ fundamental right. Part 3 का अगर वायलेशन होता है, then you can go to the Supreme Court. 226 में it is not just relating to part 3 कि अगर fundamental right का violation हुआ, then of course you can go, and it also gives the power to the High Court कि in the interest of justice, even if it is something which is not relating to fundamental rights, but in the interest of justice, the High Court can entertain a case and issue a writ. Right? So therefore, under 226, this power is wider. Can you exercise them? Do they work like an appeal? Like after you file 32, after you, let's say you file under 226, right? Here, the court gives you a decision. Can you file a case under Article 32 in appeal? Saying कि आपका यहाँ पे 226 में case reject हो गया है. But can you go and file under Article 32 in appeal? Because दोनों ही fundamental right का violation है. आप High Court से Supreme Court में जा रहे हो. Can you file an appeal under Article 32? What do you think? ये interrelations के ऊपर बहुत questions आते हैं आजकल. This understanding is very, very essential. Can you file an appeal in the Supreme Court under Article 32? No, you cannot. ठीक है, good Ayush. No, you cannot. ये जो jurisdiction है 32 की and 226 की, this is considered like a contemporary sort of a jurisdiction, right? So here they are almost like on an equal footing. जब आप 32 और 226 की बात करते हो, they are supposed to be like on an equal footing. Here 32 is not going to be an appellate jurisdiction, right? If 226 में कोई judgment High Court ने pass करा है on the same issue, Ayush is saying भाई doctrine of res judicata लगेगा. Doctrine of res judicata तब लगेगा जब हम बात कर रहे हैं कि I have filed a fresh case in the High Court, I have lost that case, and then under Article 32 again I file a fresh case. Then comes the doctrine of res judicata, because here I cannot file two cases at the same time. Right? On the other hand, जब आप हम अपील की बात कर रहे हैं तो अपील जो होता है वो डिफरेंट होता है. अपील आप 32 के अंडर नहीं फाइल करोगे, अपील आप अलग प्रोविजन के अंडर फाइल करोगे. Right? So that is going to be different. Okay? चलो. Any which ways, that was something. Okay, now let's move on. This is doctrine of judicial review. Next is the doctrine of reasonable classification. Now, reasonable classification कौन से article में आता है? Does anybody remember? Reasonable classification किस concept से related है? Now, the slide here is clearly telling you that reasonable classification is dealing with equality. So, which is the article of the Constitution which deals with both the things? I know, ma'am, आप हमारी knowledge की class क्यों ले रहे हो? Legal CLAT में knowledge नहीं आएगा. I understand. So, I'll help you out if you cannot tell me. Equality. Right to equality is your Article 14. Right to equality starts with Article 14. The general article, good Ayush, the general article on good Tanvi, the general article on equality starts with 14, and it gives you these two concepts. It talks about equality before law and talks about equal protection of laws, right? Now, equality before law means that everybody, law is going to treat everybody equally. Right? So whether you are rich, you are poor, you are man, you are woman, you are child, you are whatever, equality before law generally would mean that everyone would be treated equally. On the other hand, when you're talking about equal protection of laws means that all the laws would be applicable to people equally, right? So जितना मुझे आप law apply करेगा, उसी तरह से किसी और को भी law apply करेगा, right? So basic both of them talk about the concept of equality. The question arises, does it mean that law or in law, equality means that everyone would be treated equally? कि everyone जो है सबको एक बराबर हम equally treat करेंगे? Obviously not, right? So in law, equality does not mean that everyone is going to be treated equally, but rather we say that equals would be treated equally. And since we're talking about equals to be treated equally, that is when we say that the same law should not apply to every individual, but it would apply to a class of people. राइट. सो हमारे यहाँ इफ यू लुक एट आर्टिकल 15, 16 जो बाकी कॉन्स्टिट्यूशन में इक्वालिटी से रिलेटेड चीजें हैं, आई एम श्योर ऑल ऑफ यू स्टडीड देम. इन दैट यू वुड रियलाइज दैट यू हैव कास्ट एंड सेक्स एंड क्रीड एंड all those race and all those things are given as grounds for discrimination. Class per se is not given. That is why जब हम यहाँ पे doctrine of reasonable classification कर रहे हैं, so you can differentiate people on different classes. In different classes, you are going to treat people differently so that actual substantial equality can be brought around, right? So when you're talking about classification, or classification can happen, these are the two important things which need to be there. Only then this reasonable classification happens. Because when you are talking about creating a class, because you are saying that equals will be treated equally, everyone will not be treated equally. तो जब equals will be treated equally की बात आती है, तब आता है आपका concept of reasonable classification. कि आप जब classification करोगे, वो उसका basis कैसा होना चाहिए? Reasonable, right? So here, when you look at these two things, intelligible differentia and rational nexus, what you come across is that there has to be a basis for the classification. Basis kaisa hona chahiye? It should be something which is based on intelligible differentia. Intelligible differentia means कि क्या basis है? कोई आपका basis होना चाहिए, कोई reason होना चाहिए for creating classification. And this basis, how should this basis be? This basis should be such which has a rational nexus. Rational nexus means it should have some sort of a relation to the object which the act is trying to achieve. So if you are talking about creating a reasonable classification का कोई basis होना चाहिए, कोई logic होना चाहिए, ऐसा logic, ऐसा relation, ऐसा logic, ऐसा basis which is going to have a rational nexus, which is going to have some sort of a relation with the object. तो आपके object को achieve करने में वो help करेगा, then it is going to be valid. Otherwise, it is not going to be valid, right? Like जैसे कि आपका contract act है. Now, I'll give you an example from something which all of you have studied for CLAT. When you look at the concept of contract में, can anybody and everybody enter into a contract? No, right? If you want to enter into a contract, वहाँ पे competencies there is a clause, right? And one of the competency clause is that it's supposed to be, they say that you have to be a major, right? If you're a minor, then you cannot enter into a contract. So looking at this concept of minority, what are you doing? You are creating a classification. आपने classification create किया है, और ये classification कैसा है? This classification, this is the basis, this minority. Now, is it able to achieve the object that you are trying to achieve? Yes, because when you're looking at a minor may not be able to, fully comprehend the terms of the contract. भी उसके benefit में क्या है, क्या नहीं है, उसको इतना समझ में नहीं आ सकता. That is when we say that when it comes to minority, that would be a classification which has a relation to the object which is trying to achieve. On the other hand, if let's say I say that contract में enter कौन नहीं कर सकता? Somebody who has long hair, somebody who has blonde hair, they cannot enter into a contract. अब ये जब मैंने basis बनाया अपना classification का, is there any object which I can be achieving? Obviously not, right? तो अब यहाँ पे ये जो मैं object के साथ मेरा relationship नहीं बन पा रहा है, that is when we say it is something which is not going to be considered as reasonable classification. So there has to be both the things. There has to be intelligible differentia and there has to be a rational nexus, right? The reason I'm giving you a detailed explanation on these things is normally जब exam में ये words आ जाते हैं, intelligible differentia, rational nexus, one tends to get a little flummoxed कि ये है क्या. So just have a clear understanding. Rational nexus is very simple कि भैया जो आपने basis create किया है उसके बीच में और आपका जो object है उसके बीच में कोई relationship है. If it exists, then it is known as a rational nexus. Otherwise, not. Okay? So that's your second. इसमें डॉक्ट्रिन ऑफ रीजनेबल क्लासिफिकेशन में कई बार एक और कॉन्सेप्ट आता है आर्बिटरीनेस का. That you have the doctrine of arbitrariness. Arbitrariness means that it cannot be unreasonable. There has to be some sort of a reason whenever you are creating a classification. If that reason does not exist, then this classification will be considered as invalid or void. Right? So this is your doctrine of reasonable classification. So Tanvi is asking, so intelligible differentia should be the basis to achieve rational nexus. See, intelligible differentia is the basis. When you are talking about intelligible differentia, that's exactly what the basis is. Right? So that is the basis, and on the basis of this, you are achieving the objective. ठीक है, जैसे कॉन्ट्रैक्ट वाले एग्जाम्पल में हमने करा कि भाई एक माइनर को आपने क्लासिफिकेशन क्रिएट किया है. अच्छा, एक और एग्जाम्पल देती हूँ इसमें. ये एक्चुअल रियल लाइफ में हुआ था. देयर इज दिस आई डोंट रिमेम्बर, साउथ का कोई स्टेट था जहां पे हाईकोर्ट के सामने केस आया कि भाई एक पर्टिकुलर जेल थी, उन्होंने क्या किया था शुरू करना, दैट देयर आर ऑफेंसेस अगेंस्ट वुमेन. सो वो ऑफेंसेस अगेंस्ट वुमेन तो है ही खतरनाक, जिनके लिए वैसे ही पनिशमेंट काफी ज्यादा होती है. एंड ये पुलिस वालों ने, एडमिनिस्ट्रेशन ने क्या करना शुरू किया, दैट पीपल हु आर हेल्ड लायबल फॉर ऑफेंसेस अगेंस्ट वुमेन, उनके लिए उन्होंने जेल में अलग सेक्शन बना दिया. सो दिस एंटायर बड़ी सी जेल है यहाँ पे, और उस जेल में एक इन्होंने छोटा सा सेक्शन बना दिया कि भाई यहाँ पे ऑफेंसेस अगेंस्ट वुमेन जो लोग कमिट करेंगे उसको इस पार्ट ऑफ द जेल में रखेंगे और बाकी के जेल के कैदियों से अलग. So there was a classification which was created in the jail on the basis of the fact that these people had committed offenses against women and rest of them were normal, अपने चोर डाकू जो भी थे. तो यहाँ पे tell me, do you think this classification can be considered reasonable? अब यहाँ basis क्या है? The fact that whether you have committed an offense which was against a woman or whether it was offense which is in general. That is your basis. That is the intelligible differentia which is being used. Now, what could be the possible object that you could be trying to achieve? Okay, clearly आ गया आसिक और तन्वी का कि भाई नहीं ये तो गड़बड़ है, which is very true. Because here पनिशमेंट कम ज्यादा दे रहे हो, ठीक है, बिकॉज ऑफेंस ज्यादा हीनियस है, ऑफेंस कम हीनियस है, ऑल दैट इज ओके. बट यहाँ पे once they've been tried and they're being put in the jail, to create a separate part on the jail for the people who are who've been held guilty of offenses against women, that is something which is illogical, right? Does not really have any rational nexus with the object that they're trying to achieve. ठीक है, so therefore this was held to be void. ठीक, क्योंकि unreasonable count किया था. Still exists? No, court set it aside. This came to the court and the court set it aside कि भाई नहीं, अलग अलग जेल नहीं, जेल तो एक ही होगी. Offense आपने commit किया, that's okay. ठीक है. Next is, I hope so. Okay, I hope this reasonable classification is clear. This is the basic criteria behind your Article 14. ठीक. Next is doctrine of basic structure. I'm sure the moment this slide came in, you'd be like, okay, we've had enough of doctrine of basic structure. But still a general reminder as to what doctrine of basic structure is. Doctrine of basic structure, very, very important, deals with the concept of amendment of the constitution, right? So important cheez, ye baat kar raha hai amendment of the constitution ki. Prior to this doctrine, which came into existence in 1973, there used to be huge controversies कि भाई क्या हमारा पूरा का पूरा constitution है वो amend हो सकता है या कुछ parts हैं जो amend हो सकते हैं. So with Keshwanand Bharati versus State of Kerala in 1973, wherein this doctrine was laid down. How many judges were there in this case? How many judges were there in this case? This is something which is, which is like a trivia sort of a thing, which is always nice. Thirteen, right? 13 judges. Yes, 13 judges in this bench of the Supreme Court. Why? What did they do? They wanted to check whether, which part of the constitution can be amended and which part cannot be. सबसे ज़्यादा controversy क्यों हो रही थी? Because fundamental right के ऊपर कि भाई fundamental right वाला जो chapter है, फंडामेंटल राइट वाला चैप्टर है, शुड इट बी अमेंडेड और शुड इट नॉट बी अमेंडेड, कैन इट बी अमेंडेड और कैन इट नॉट बी अमेंडेड. सो व्हाट डिड दे डू? They came up with the concept of basic structure. Basic structure says that there are certain basic features which cannot be altered or destroyed, right? And even though they came up with this concept, but they did not say that what is meant by basic structure. The basic structure में क्या क्या include होगा, क्या क्या include नहीं होगा, that was not something which was told. Right? कुछ चीजें उन्होंने examples दिए, like democracy, federalism, independence of judiciary, secularism. These were the examples which were given, but they left it open. Right? तो ये एक open-ended definition है. So as and when case by case basis, the court will have the power to decide कि भाई ये basic structure का part है या नहीं. If it is a part of basic structure, then you cannot amend it. If it is not a part of basic structure, then you can amend it, right? So that is that's the basic concept behind the basic doctrine of basic structure. ठीक? Chalo, I hope this is clear to everybody. Fairly simple, something you have come across a lot of times. Next is your doctrine of harmonious construction. अब harmonious construction जो है ना, this is a doctrine which is not used only in constitution. This is a doctrine which is used across the board. कॉन्स्टिट्यूशन में भी यूज होता है, बट अक्रॉस द बोर्ड भी यूज होता है. हार्मोनियस कंस्ट्रक्शन मीन्स व्हेनेवर देयर आर एनी टू कॉन्फ्लिक्टिंग लॉज, दीज लॉज कुड बी सेपरेट लॉज ऑल टुगेदर, और दिस कुड बी कि एक ही एक्ट में दो अलग अलग प्रोविजन है, उनका कॉन्फ्लिक्ट हो रहा है आपस में, उनका देयर इज अ कॉन्फ्लिक्ट व्हिच इज हैपनिंग. सो व्हेनेवर देयर इज अ कॉन्फ्लिक्ट हैपनिंग, यू ट्राई टू अराइव एट अ सोल्यूशन जहां पे हार्मोनियसली दोनों साइड को आप कंस्ट्रू करके हार्मनी मिला के यू come to a decision. You do not come to a decision wherein one wins and the other loses. And so that is not how it should be. It should be that whatever is the situation, jahan overlap ho raha hai, jahan pe kuch bhi ho raha hai, it should be you take everything together, harmonize it, and then try to arrive at a solution, right? So that is what the approach has to be. So similarly, jab ye constitution mein use hota hai, so it is used in two things. Now when you are looking at those two things, now those two things are, first when you talk of the lists, the three lists which are there, so there can be an overlapping of the three lists which are mentioned in the 7th schedule. So wahan pe again you have the concept of harmonious construction which comes in. And the second place where concept of harmonious construction which comes is when you're talking of where there is a conflict between fundamental right and directive principles, right? So jahan aapki lists aati hain, wahan pe bhi aapka harmonious construction hota hai. एंड जहां पे आपका कॉन्फ्लिक्ट बिटवीन फंडामेंटल राइट्स एंड डायरेक्टिव प्रिंसिपल्स होता है, वहां पे भी हार्मोनियस कंस्ट्रक्शन हैपेंस, राइट? सो दीज टू प्लेसेस इज वेयर द डॉक्ट्रिन ऑफ हार्मोनियस कंस्ट्रक्शन कम्स इनटू बीइंग. इफ देयर इज अ कॉन्फ्लिक्ट बिटवीन फंडामेंटल राइट्स एंड डीपीएसपी, सबसे पहले आप ट्राई करोगे हार्मोनियस कंस्ट्रक्शन करने का. इन केस हार्मोनियस कंस्ट्रक्शन फेल हो जाता है, देन हु इज गोइंग टू, which is going to be held valid, the DPSP or the fundamental right, which would prevail? First you try the harmonious construction, but let's say you do not succeed in the harmonious construction, then which is going to be there? Quickly tell me. It is going to be the fundamental rights which are going to prevail, because this is that part of the principle which is enforceable. ठीक है, बाकी तो enforceable नहीं है, right? Okay. Now, okay, Tanvi has a doubt. If judicial review is part of basic structure, then how is 9th schedule immune to it? See, it is given, the constitution itself provides for it, right? And when you are saying that if it is a part of basic structure, does it mean that it is something which is going to be applicable everywhere? Basic structure means that judicial review cannot be taken out of the constitution. You cannot have the constitution being amended in a manner that judicial review is completely removed from the purview of the constitution. That is what is meant when you are saying that you cannot amend it in a manner that it goes against the basic structure, right? Whereas if you look at the Schedule 9, Schedule 9 is specifically being given within the Constitution itself. So it is within the domain of the Constitution that they have put in a rider that, okay, so far as Schedule 9 is concerned, that is something for which judicial review is not going to work. Take? Chalo. I think we should call it a day right now. And next class is when we will begin with rest of the doctrines. Next Thursday when we meet. And in the meanwhile, let me hustle up the legal GK also, so that a session thereafter we will do a quick checklist of the legal GK which has to be there. Take care. So I hope everybody was able to understand what we did today. It was, in quite some manner, it was like a quick revision also, because these concepts you might have done quite some time back. And a lot of times, when we revise, we don't have things which are together at one place, right? So that is something which we can do, right? Okay. Yes. Chalo. Theek hai, Hasika, we can do that. Okay. Yes, I know 2020 ka paper is very difficult. We would be discussing in the class also. We can do that as well, right? Chalo then. Thank you so much and take care, everybody. And just in case you are new to this channel, if you're watching this video, you're somebody who's not part of our Clat Possible family, we are this institute called Clat Possible. We help students prepare for their CLAT exams. And just in case, if you need help, support in any manner, then we are there to do that, right? Okay, then thank you so much, everybody. Take care and best of luck with your preparation. See you next Thursday. That's when we meet, Thursday to Thursday, live every Thursday at 7 p.m. Right? I'm Neha, and I would love to see you guys back. And if you're new, you haven't seen me around, please do join in at live. We have a live session every Thursday at 7 p.m. Okay.